Greetings, everyone. Today we're going to discuss status and standing. This is a continuation of our previous discussions. We are going to go over what it takes to live and be sovereign, what is keeping you from enforcing your inalienable rights, and dispel some myths floating around the sovereign citizen community. Our intention to this webinar series and our redemption secured party creditor process is to give you all the tools you'll need to remove yourself from undisclosed adhesion contracts, reestablish your status and standing as an American national and private state citizen, discharge debt and or settle claims properly, access the common law side of the courts, challenge jurisdiction, protect your property, and leave a legacy to your heirs and not Uncle Sam. Now, this webinar is packed with information, so let's get started. What is your status? Do you know where you stand in commerce? How about in regards to the law? Many Americans assume that their status and standing when it comes to the law, but many have been misled through lies, deception, fraud, and propaganda. Understanding status is essential. All individuals take a position at law and in commerce when entering into any contract or agreement. Under natural law, there is no limit to your rights and power to contract unless you waive or limit those rights by consent or tacit agreement. Your status plays a big role in determining your position when it comes to the enforcement of your rights and claims in commerce and at law. In order to understand where you currently are, it helps to examine relationships, circumstances, and events that got you there. Let's now take a look at how history has led us to where we are now today. Under the English feudal system, as practiced in the Kingdom of England, the state of human society was formally structured and stratified on the basis of land tenure and the varieties thereof. Society was thus ordered around relationships derived from holding of land, which land holdings are termed fiefdoms, fiefs, or fees. Under the English feudal system, several different forms of land tenure existed, each effectively a contract with differing rights and duties attached thereto. Such tenures could be either freehold, signifying that they were heritable, or perpetual, or non-free, where the tenancy terminated under the tenant's death or at an earlier specified period. Sestake, also sestuke or sestake, is a shortened version of a sestake use le fiefment fui fait, literally the person for whose use the fiefment was made. It is a law French phrase of medieval English invention, which appears in the legal phrases sestake trust, sestake use, or sestake vie. In contemporary English, the phrase is commonly pronounced setike or sestake. According to Roebuck, sestake use is pronounced sestike use. Sestake use and sestake trust are more or less interchangeable terms. In some medieval materials, the phrase is seen as sestake or sestake. In the Middle Ages, especially in the European feudal system, fiefment or enfeoffment was the deed by which a person was given land in exchange for a pledge of service. This mechanism was later used to avoid restrictions on the passage of title in land by a system in which a landowner would give land to one person for the use of another. The common law of estates and land grew from this concept. The sestake use is the person for whose benefit the trust is created. The sestake trust is the person entitled to an equitable as opposed to a legal estate. Thus, if land is granted to the use of A in trust for B, A is the sestake trust and B trustee or use. The term, principally owing to its cumbersome nature, has been virtually superseded in modern law by that of beneficiary and the general law of trust. The sestake use and trust were rooted in medieval law and became a legal method to avoid the feudal incidents or payments to an overlord, while leaving the land for the use of another who owed nothing to the lord. The law of sestake tended to defer jurisdiction to the courts of equity as opposed to common law courts. The sestake was often utilized by persons who might be absent from the kingdom for an extended time, as on a crusade, or a business who might be absent, or a business adventure, and who held tenancy to the land and owed feudal incidents to a lord. The land could be left for use of a third party who did not owe incidents to the lord. This legal status was also invented to circumvent the statute of mortmain, The statute intended to end the relatively common practice of leaving real property to the church at the time of the owner's death. Two conceptualizations, not mutually exclusive, of the term mortmain, which in French means dead hand, of the terms explain its origins. First, the dead hand may be characterized as that of the deceased donor and former owner to whose desire, as embodied in the testamentary provision that the church hold title to the property, remains subject. Second, because the church as a non-natural person recognized at common law never died, the land never left the dead hand, or more accurately, the non-living hand of the church. Before the statute of mortmain, large amounts of land were bequeathed to the church, which never relinquished it. This legal arrangement was in contradistinction to others in which the land could be transferred to anyone, inherited only through a family line, sometimes sex-specific, or revert to a lord or the crown upon death of the tenant. Church land has been a source of contention between the crown and the church for centuries. Cestui use allowed religious orders to inhabit land, while the title resided with a corporation of lawyers or other entities who nominally had no relation to the church. Cestui v. Act 1666. Cestui v. remaining beyond sea for 7 years together and no proof of their lives, judge in action to direct a verdict as though Cestui v. were dead. If such persons or persons whose life or lives such estates have been or shall be granted as aforesaid shall remain beyond the seas or elsewhere absent themselves in this realm by the space of 7 years together, and no sufficient and evident proof be made of the lives of such person or persons respectively, and any action commenced for recovery of such tenements by the lessors or revisioners, in every such case the person or persons upon whose life or lives such estate depended shall be accounted as naturally dead, and in every action brought for the recovery of the said tenements by the lessors or reversioners, their heirs or assigns, the judges before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the seas, otherwise absenting himself, were dead. Section 4. If the supposed dead man prove to be alive, then the title is revested, action for mean profits with interest, provided always that if any person or persons shall be evicted out of any lands or tenements by virtue of this act, and afterwards if such person or persons upon whose life or lives such estate or estates depend shall return again from beyond the seas, or share on proof in any action to be brought for recovery of the same, to be made appear to be living, or to have been living at the time of the eviction, and that from thenceforth the tenant or lessee who was outed of the same, his or her executors, administrators, or assignees, shall or may re-enter, repossess, have hold, and enjoy said lands or tenements in his or her former estate for and during the life or lives of, or so long term as the said person or persons upon whose life or lives the said estate or estate depends shall be living, and also shall upon action or actions to be brought by him or them against the lessors, reversioners, or tenants in possession or other persons respectively, which since the time of said eviction receive the profits of the said lands or tenements, recover for damages the full profit of said lands or tenements respectively, with lawful interest for and from the time that he and they were outed of the said lands or tenements, and kept or held out of the same by said lessors, reversioners, tenants, or other persons who after the said eviction receive the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate did depend are and shall be dead at the time of bringing of said action or actions, as if the person or persons were then living. From public law to public policy. Our government has reverted to the old ruler's law, with nobles and lords reigning over its loyal subjects. Judges, attorneys, senators, congressmen, and presidents have all accepted special titles of nobility and powerful positions in the privileged ruling class of America. This legal fraternity has taken over the reins of government and has maintained a monopoly over all three branches ever since. The original 13th Amendment is a profound challenge to the de facto government and legal fraternity that presently rules the federal United States and all its political subdivisions. The Supreme Court has declared the Agricultural Adjustment Act and National Industrial Recovery Act, which were major components of Roosevelt's New Deal legislation, unconstitutional in 1935. President F.D. Roosevelt, not to be derailed by the Supreme Court, under the authority of his declared state of national emergency, then demanded a reorganization of the entire federal judiciary, directly challenging the independence of the judicial branch of government as guaranteed by the Constitution. This precipitated a change in our American system of law from public common law to public international bankers' policy or private commercial law. The legislative bodies in America are now the sovereigns over the courts, executive officers, and its so-called U.S. citizens. Their function is solely to pass public policy statutes in the interest of the nation's principals and creditors, wherein civil statutes contain criminal penalties under an admiralty jurisdiction. The new and improved Supreme Court after FDR ruled that all cases will be judged under the negotiable instruments law. See Erie Railroad versus Tompkins, 1938. After this case, common law was officially blended with the procedures of equity. New federal rules of civil procedure took effect along with the Social Security Act of 1938. In the next 10 years, the Court of Common Pleas began to disappear, and virtually every American became a U.S. citizen by enrolling in the Social Security system. The sovereignty of the states and its respective state citizens was almost completely destroyed by this federal corporate socialist coup d'etat. Since the Civil War, the state has usurped its power from the American people through bureaucratic threats, duress, coercion, and manipulation of the economic and legal system. The state has been at war against the American people since then. The government bureaucracy took advantage of the civil disobedience and dissent to strip Americans of their sovereignty, and have been chipping away at the limited authority and jurisdiction enumerated and placed upon the federal and state governments through the Constitution and Bill of Rights. In 1863, Lincoln declared a state of martial law and suspended the writ of habeas corpus in 1861 through the General Orders 100, known as the Lieber Code, or the Code for Government Armies in the Field. The code was authored by Francis Lieber, a jurist and political philosopher from Germany who was a professor of history and political science at Columbia College, currently Columbia University. Lieber assisted the War Department and President Lincoln in drafting legal guidelines for the Union Army. These guidelines became known as the Lieber Code. Under Article 4 of the Lieber Code, martial law is defined as follows. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as the dictation of general laws as far as military necessity requires the suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. Lincoln was assassinated shortly after the end of the Civil War, and General Order 100 was never repealed, or peace was never officially declared to end martial law. Accordingly, Americans have been under a perpetual state of war with the United States and under military rule and occupation ever since. Under Article 2 of the Code, it states, martial law does not cease during the hostile occupation except by special proclamation, ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. The Constitution for the United States of America was originally written as a contract between the federal government in the District of Columbia and free white males of the 13 original incorporated colonies that became states of the United States of America. These are the only parties to the contract of organic law for the government, besides those who later became naturalized citizens. The United States and the United States of America mean two different things when speaking in legal terms or legalese. The free white men of their 13 original colonies ordained the Constitution for or on behalf of the United States of America, which were the 13 sovereign states at that time, and their posterity or descendants. After the war, Congress passed the 13th Amendment ending slavery and involuntary servitude. Then they passed the 14th Amendment, creating a new class of citizenship, the subject citizen, through denationalization. A subject citizen was a corporate citizen or a subject of the de facto military government now in operation. Now, for the first time, legal entities, i.e. corporations, limited companies, and partnerships, could become citizens under the 14th Amendment and have legal rights under this status. Denationalization, the act of stripping a national group of their nationality and political identity. An example of denationalization can be found in the 1947 Nuremberg trial of Ulrich Greffelt and others. During the proceedings, a reference was made to the war crime of denationalization, citing the policy of forcibly Germanizing some groups within the local population of occupied Poland. Among the groups so treated were Poles, Alsace-Lorrainers, and Slavons, as well as others deemed eligible for Germanization under German's People's List. Legal tender. Under the 14th Amendment, the validity of the public debt shall not be questioned. In 1862, during the Civil War, the issuance of paper greenbacks as legal tender and circulating medium of exchange occurred under our current monetary system. Under the pretext of the War Powers Act, Congress authorized the issuance of non-interest-bearing treasury notes and declared the bills of credit to be legal tender for all debts, public and private, with the exception of taxes on imports. The notes were deemed necessary to float the debt of the United States for the war effort. On June 3, 1864, Congress passed the National Currency Act, also termed the National Bank Act, to provide a national currency secured by a pledge of the United States bonds and to provide for the circulation and redemption thereof. This act recreated the central banking system as a national association, which later evolved into the current Federal Reserve banks. All private banknotes issued under authority of the act were issued and circulated the same as money, had to be redeemable at par value, 1-for-1 with the coin, and were declared to be tender for the payment of all debts, public and private, under Section 23. Pledging or hypothecating any of these notes in circulation under this act was prohibited under Section 37. On December 23, 1913, Congress passed an act to provide for the establishment of Federal Reserve banks, to furnish an elastic currency, to afford a means of rediscounting commercial paper, to establish a more effective supervision of banking in the United States, and for other purposes. The act is commonly known as the Federal Reserve Act. Some of the purposes for enacting the Federal Reserve Act were to: 1. Collect 94% of the net earnings of the Federal Reserve banks under pretense of a franchise tax under Section 7. Legalize and extend the float on the debts by reducing the backing or reserve requirements to 40% of the notes in circulation and transaction accounts under Section 11. Authorize hypothecation of obligations including United States bonds or other securities which the Federal Reserve banks are authorized to hold under Section 14A, and establish branches in foreign countries or dependencies of the United States for the furtherance of foreign commerce of the United States under Section 25. It is important to understand the term hypothecation as stated in Section 14A of the Act. Under banking, offer of stocks, bonds, or other assets owned by a party other than the borrower as collateral for a loan without transferring title. If the borrower turns the property over to the lender who holds it for safekeeping, the action is referred to as a pledge. If the borrower retains possession but gives the lender the right to sell the property in the event of default, it is a true hypothecation. Securities. The pledging of negotiable securities to collateralize a broker's margin loan. If the broker pledges the same securities to a blank as collateral for a broker's loan, the process is referred to rehypothecation. Dictionary of Banking Terms, Fitch, page 228, 1997. Section 16 of the Federal Reserve Act, which is codified at 12 U.S.C. 411, declares that Federal Reserve notes are obligations of the United States. The full faith and credit of the United States was thereby hypothecated and rehypothecated to the lending institutions for the issuance and emission of bills of credit as legal tender for all taxes, customs, and other public dues. The paper in circulation and transactions accounts could then be inflated 60% and the purchasing power depreciated and reduced by an equivalent amount. The final nail in the coffin of lawful money in the United States was with the passage of the 192nd House Joint Resolution, HJR 192, Public Law 7310 in 1933. This resolution made it against public policy to require payments in gold or a particular kind of coin or currency or in any amount in money of the United States. Now that all lawful money has been removed from circulation, there can be no payment of debts, only novation and or discharge. Novation is the act of substituting a new obligation for an old debt that replaces an original party with a new party. Every time someone pays for something with a Federal Reserve note, they have essentially created a novation, and that debt is transferred to an obligation backed by the full faith and credit of the United States. Discharge is any method by which a legal duty is extinguished by any of the following means: the payment of a debt or satisfaction of some other obligation, the release of a debtor from monetary obligations upon adjudication of bankruptcy, the dismissal of a case, and the canceling or vacating of a court order, and the release of a prisoner from confinement. The 16th Amendment to the United States Constitution allows Congress to levy an income tax without apportioning it among the states or basing it on the United States Census. This amendment exempted income taxes from the constitutional requirements regarding direct taxes after income taxes on rents, dividends, and interest were ruled to be direct taxes in the court case Pollock versus Farmers Loan and Trust Company, 1895. The amendment was adopted on February 3, 1913. The Congress should have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. In Pollock versus Farmers Loan and Trust Company, the U.S. Supreme Court declared certain taxes on incomes, such as those on property under the 1894 Act, to be unconstitutionally unapportioned direct taxes. The court reasoned that a tax on income from property should be treated as a tax on property by reason of its ownership, and so should be required to be apportioned. The reason was that taxes on rents from land, the dividends from stocks, and so forth burden the property, generating the income in the same way that a tax on property by reason of its ownership burdened that property. After Pollock, while income taxes on wages as indirect taxes were still not required to be apportioned by population, taxes on interest, dividends, and rental income was required to be apportioned by population. The Pollock ruling made the source of the income, ergo property versus labor, etc., relevant in determining whether the tax imposed on that income was deemed to be direct, and thus required to be apportioned among the states according to population, or alternatively indirect, and thus required only to be imposed with geographical uniformity. Dissenting in Pollock, Justice John Marshall Harlan stated, "When therefore this court adjudges, as it does now adjudge, that Congress cannot impose a duty or tax upon personal property or upon income arising either from rents of real estate or from personal property, including invested personal property, bonds, stocks, and investments of all kinds, except by apportioning the sum to be so raised among the states according to population, it practically decides that without an amendment of the Constitution, 2/3 of the House of Congress and 3/4 of the states concurring, such property and incomes can never be made to contribute to the support of the national government." Members of Congress responded to Pollock by expressing widespread concern that many of the wealthiest Americans has consolidated too much economic power. The United States Revenue Act of 1913, also known as the Tariff Act, Underwood Tariff, Underwood Act, Underwood Tariff Act, or Underwood-Simmons Act, Chapter 16, 38 Statutes at Large, 114, October 3rd, 1913, reimposed the federal income tax following the ratification of the 16th Amendment and lowered basic tariff rates from 40% to 25%, well below the Payne-Aldrich Tariff Act of 1909. The act also provided for the reinstitution of federal income tax as a means to compensate for anticipated lost revenue because of the reduction of tariff duties. The most recent effort to tax incomes, the Wilson-Gorman tariff of 1894, had been declared unconstitutional by the Supreme Court because the tax on dividends, interest, and rents had been deemed to be a direct tax not apportioned by population. That obstacle, however, was removed by ratification of the 16th Amendment on February 3rd, 1913. The Act provided in part that, subject only to such exemptions and deductions as are hereinafter allowed, the net income of a taxable person shall include gains, profits, and income derived from salaries, wages, or compensation for personal service of whatever kind and in whatever form paid, or from professions, vocations, businesses, trade, commerce, or sales, or dealings in property, whether real or personal, growing out of the ownership or use of or interest in real or personal property, also from interest, rent, dividends, securities, or the transaction of any lawful business carried on for gain or profit, or gains or profit and income derived from any sorts whatsoever. The income of couples exceeding $4,000 as well as those of single persons earning $3,000 or more were subject to a 1% federal tax. Further, the measure provided a progressive tax structure, meaning that the high income earners were required to pay at higher rates. It would require only a few years for the federal income tax to become the chief source of income for the government, far outdistancing tariff revenues. Less than 1% of the population paid federal income tax at that time. The United States Revenue Act of 1916 raised the lowest income tax rate from 1% to 2% and raised the top rate to 15% on taxpayers with incomes above $2 million. Previously, the top rate had been 7% on income above $500,000. The act also instituted the federal estate tax. The entry of the United States into World War I greatly increased the need for revenue. An excess profits tax was introduced and the modern estate tax was imposed. The act was applicable to incomes for 1916. The current Tax Payment Act of 1943 reintroduced the requirement to withhold income tax in the United States. Tax withholding had been introduced in the Tariff Act of 1913 but repealed by the Income Tax Act of 1916. The current Tax Payment Act compelled employers to withhold federal income taxes from workers' paychecks and pay them directly to the government on workers' behalf. At the time of the act, Social Security payments and a World War II victory tax were already being withheld. Maternity Act. Here's an excerpt from Are We Federal Children Owned by the Government by Dave Champion. In 1921, the Federal Shepherd-Towner Maternity Act created the birth registration, or what we now know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. One of these other purposes provided for the establishment of a federal bureau designed to cooperate with state agencies in the overseeing of its operation and expenditures. What it really did was create a federal birth registry which exists today, creating federal children. This government, under the doctrine of parens patriae, now legislates for American children as if they're owned by the federal government. Through the public school enrollment process and continuing license requirements for most aspects of daily life, these children grow up to be adults indoctrinated into the process of asking for permission from government to do all those things necessary to carry out daily activities that exist in what is called a free country. Before 1921, the records of births and names of children were entered into family Bibles, as were the records of marriages and deaths. These records were readily accepted by both the family and the law as official records. Since 1921, the American people have been registering the births and names of their children with the state in which they were born, even though there is no federal law requiring it. The state tells you that registering your child's birth through the birth certificate serves as proof that he or she was born in the United States, thereby making him/her a United States citizen. For the past several years, a Social Security number was mandated by the federal government to be issued at birth. The state claims an interest in every child within its jurisdiction. The state will, if it deems it necessary, nullify your parental rights and appoint a guardian or trustee over your children. The subject of every birth certificate is a child. The child is a valuable asset which is properly trained, if properly trained, can contribute valuable assets provided by its labor for many years. It is presumed by those who have researched this issue that the child itself is the asset of the trust established by the birth certificate, and the Social Security number is the numbering or registration of the trust, allowing for the assets of the trust to be tracked. If this information is true, your child is now owned by the state. Each one of us, including our children, are considered assets of the bankrupt United States. We are now designated by this government as human resources or chattel. Some examples of the measures to which people of the states which accept the provisions of the Act may be subject include the forced registration of pregnancy, governmental prenatal examination of expectant mothers, restrictions on the right of a woman to secure the services of a midwife or physician of her own selection, the payment of subsidies out of federal appropriations, insurance of mothers may be made compulsory, the teaching of birth control, and physical inspections of persons about to be married may be required. The Act has been found unconstitutional by the courts. It purports to vest in agencies of the federal government powers which are almost wholly undefined in matters relating to maternity and infancy, and to authorize appropriations of federal funds for the purpose of the Act. In McCullough versus Maryland, they ruled that the Act is invalid because it assumes powers not granted to Congress and usurps the local police power. In Hammer versus Dagenhart, in more recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based on one of the powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulation of a matter wholly within the police power of the states will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. In the message of President Monroe, May 4, 1822, the Act is not made valid by the circumstances that federal powers are to be exercised only with respect to those states which accept the Act, for Congress cannot assume and state legislatures cannot yield the powers reserved to the states by the Constitution. In Harrison versus St. Louis and San Francisco Railroad Company, they ruled that the Act is invalid because it imposes on each state an illegal option either to yield a part of its power reserved by the 10th Amendment or to give up its share of appropriations under the Act. A statute attempting by imposing conditions upon a general privilege to exact a waiver of a constitutional right is null and void. And in Knickerbocker Ice Company versus Stewart, they ruled that the Act is invalid because it sets up a system of government by cooperation between the federal government and certain of the states not provided by the Constitution. Congress cannot make laws for the states, and it cannot delegate to the state the power to make laws for the United States. The Maternity Act was eventually repealed, but parts of it has been found in other legislative acts. What this act attempted to do was set up government by appointment, run by bureaucrats, with re-delegated authority to tax, which in itself is unconstitutional. Once declared as unconstitutional by the Supreme Court of this nation in the past, it should be upheld in a court challenge today. Part 2, Adhesion Contracts. The issue of status in commerce is simply one of how we enter into contract. In doing business with the United States and or its agents, we are the source of commercial energy in any contractual relationship. Commercially, we are typically engaged in transfers for most transactions. Transfers are activities that take energy, goods, and services from one party, but no value or detriment is received in return. The nature of this oppression is mostly invisible. Americans are being forced into an economic and political slavery by an elite aristocracy and consortium of international banksters through unlawful foreclosures, forfeitures of property, and a war on crime and drugs. Why is it important to understand the nature of these invisible or adhesion contracts? Because when a commercial contract is in effect, the Constitution is irrelevant and doesn't apply. The Constitution cannot interfere with, obstruct, intervene, or otherwise restrain the execution or operation of commercial contracts. When a commercial contract is in effect, the Constitution, namely the Bill of Rights, cannot be held to interfere with or obstruct the execution of commercial contracts for either party. George Mercier, Invisible Contracts. Juristic institutions descend to the level of commercial game players whenever they enter into the world of commerce, so it can be argued that sovereignty takes a back seat under some circumstances. We the people have an unlimited right to contract guaranteed by the Constitution and the common law preceding it. We the people also live in a commercial culture dominated by commercial agreements and contracts whereby our freedoms, rights, and sovereign state citizenship has been contracted away. Every time you sign your name on a form, you are entering a commercial agreement that can bind you to perform as specified. Some of these contracts may be harmless, ergo renting a video, yet others may bind us in ways we do not fully comprehend, ergo long-distance phone companies bind you to the law of the District of Columbia. These are called adhesion contracts. Contracts must be voluntary in nature and fully disclosed to be enforceable. The parties must also be able to perform. Adhesion contract. A contract so heavily restrictive of one party, ergo U.S. citizen, while non-restrictive to the other, ergo the government corporation, that doubts arise as to the voluntary nature of the contract. Take it or leave it basis, weaker party has no realistic choice as to its terms. Did you realize that when you completed and signed the Form 1040 tax return, you volunteered into the jurisdiction of the federal United States government, admitted being a corporate person and a federal government employee, agreed to abide by all the rules and regulations of the Internal Revenue Code, and therefore became subject to the state and federal income tax? Adhesion contracts do not bind the citizen to a commercial contract. Without the 6 elements of a valid contract, none exist. Public Law number 95-147, 91 Statutes at Large, 1227, October 28, 1977. U.S. citizens are bound by many adhesion contracts, including voters registration, marriage and business licenses, incorporation papers, selective service registration, postal addresses, bank accounts, credit cards, tax returns, social security numbers, drivers and vehicle license, and subject to tens of thousands of statutes. Here are a few examples of the hidden nature of these contracts and how they impact your freedom and life. Social security number. The completion of the SS5 application requesting an SSN creates a taxable franchise clothed with multiple layers of jurisdiction benefits. Therefore, SSN holders enter into a commercial setting, thus any enrichment and or gain is taxable. Voters registration. This is an unrevealed private contract obligating the voter or resident to pay municipal, county, and state bonds via the property tax, i.e. trustee fees, and a state income tax. Voters have also unknowingly given their power of attorney to the state. Electors are not bound to a contract or a political party. Electors are sovereign state citizens with allodial property in any state. Marriage license. This is an unrevealed private contract of the state who is a legal third party to your marriage, wherein they have control over the product, i.e. children, or the disbursement of community property via divorce. The state gets the power to take away your children if they deem it necessary for any reason. Do you want the government in your bed telling you how to raise your children? The doctrine of parens patria gives the state supremacy over parental rights. Business licenses. This negates your common law right to work in the profession and skill of your choice or talent. Do you need permission from the government to go to the bathroom as well? Free yourself from permission to contract when you have the unalienable right to contract. Incorporation. Your for-profit or non-profit business with limited liability for the payment of debt is a benefit from the government which costs the private individual 100% ownership and control over the corporation. Corporations are creations of and chartered by the state. When you are incorporating, you are now working for a government-protected enterprise and subject to all the rules and regulations thereof. When the churches incorporated, they lost not only their sovereignty and independence, but their First Amendment rights to freedom of religion as well. Don't make the same mistake. Consider other legal structures that preserve common law rights. Non-profit corporations. Non-profits are owned and controlled by the IRS and its foreign principals and creditors. If you're working in the non-profit sector, the Federal Reserve and its principal creditors are your bosses. They don't give grants and funding away without receiving control over the agendas of these organizations, some of which can be well-meaning. Selective service. Registration is for U.S. citizens only. If you place your signature on that private contract, you are bound body and soul to it. The government corporation owns you completely. They decide whether or not your teeth need pulling, not you. You have no choice once in military service. The draft is voluntary servitude. Postal addresses. Utilizing zip codes and 2-digit state abbreviations are private contracts for federal government employees. Having or using a zip code supports the presumption that you are indeed a federal employee subject to the income tax and the Form 1040. Domestic mail is within the federal United States. Non-domestic is without the federal United States, between the sovereign state citizens and the state. Bank accounts. This is one of the most insidious. Commercial contracts with banks are interstate merchant and commercial instruments, and likewise are the individuals who experience profit and gain from any commercial contract they enter with a bank. Although bank accounts are not exclusive equity jurisdiction attachments, they are conclusive evidence of the account holder's interest into interstate commerce. Unknowingly, when you open a checking account or receive a credit card and signed your name on the bank signature card, you entered a contract with a bank, which is also under contract with the Federal Reserve System, who has in turn contracted the IRS to collect taxes. In Davis versus Elmira Savings, the Supreme Court ruled, national banks are instrumentalities of the federal government created for a public purpose, and as such necessarily subject to the paramount authority of the United States. The word instrumentality means an equity relationship in which nationally chartered banks are an instrumentality of the Federal Reserve, and any profit or gain experienced from a bank carries with it the same force and effect as if the government created the gain themselves. Banking is not a substantive right, and if direct financial profit and personal gain is experienced, it can invoke an excise tax liability. This relational effect is known as the instrumentality doctrine. Black's law illustrates this point under the instrumentality rule. Under this rule, corporate existence will be disregarded where a corporate subsidiary is so organized and controlled and its affairs so conducted as to make it only an adjunct and instrumentality of another parent corporation. Under the instrumentality doctrine, the local bank as a legal entity fades away in significance as if it was transparent, and the Secretary of Treasury is the real entity you are entering into a commercial agreement with. Originally applicable only to nationally chartered banks, instrumentality doctrine has since been expanded under the Federal Reserve Act of 1913 to include all state and federally chartered member banks of the Fed, member of the FDIC, FSLIC, and SIPC. More recently, under the Frank-Dodd Act, this doctrine now includes all financial institutions where there is a federal regulatory interest in them. This includes brokerage firms, credit unions, insurance companies, and pension funds. That a national bank is an appropriate means to carry into effect some of the enumerated powers of the government, and that this can be best done by erecting it into a corporation, may be established by the most satisfactory reasoning. It has a relationship more or less direct to the power of collecting taxes, to that of borrowing money, to that of regulating trade between the states, and to those raising and maintaining fleets and armies. And it may be added that it has the most important bearing upon the regulation of currency between the states. It is an instrument which has been usually applied by governments in the administration of their fiscal and financial operations. Joseph Story in Third Commentaries on the Constitution 134. Internal Revenue Service, IRS. Responsibility for the administration and enforcement of the revenue laws is vested with the Secretary of the Treasury pursuant to U.S.C. Title 26, Section 7801. By delegation, the IRS is vested with the tax collection responsibilities for the Secretary. See Donaldson versus United States 400 U.S. 517 at 534, 1917. This chain of contracts gives authorization to the IRS to access information about your accounts, lien your assets, snoop into your records, garnish your wages, and subject you to the IRC, Internal Revenue Code. By not comprehending the power of contracts, you have unwittingly waived many of your rights by simply signing your bank signature card. We the people fall into this trap many times, creating a lengthy paper trail of presumptive evidence through these adhesion contracts, which are used to establish jurisdiction and to establish facts that can and will be used against us in a court of equity or admiralty. Presumption, an inference in favor of a particular fact, a rule of law by which finding of a basic fact gives rise to existence of presumed fact until that presumption is rebutted. There are many other adhesion contracts besides the one discussed above. An adhesion contract is one in which the state legislature or the Congress of the Federal United States government was acting as your agent or legal representative to bind you to their contract. 4 types of adhesion contracts have attached themselves unknowingly and often unwillingly. Interest, tax, statutes, and treaties. As an American sovereign state citizen, the Constitution offers no protection once you voluntarily entered into contract, having waiving your rights in exchange for any government privileges or benefits. A U.S. citizen is presumed bound to these adhesion contracts. They are as valid as if you signed each one yourself. Only a sovereign state citizen is not presumed bound to these adhesion contracts. Adhesion contracts entered unknowingly, unwillingly, or unintentionally can be nullified by declaration in the form of an affidavit, which is part of our SPC or redemption process. A U.S. citizen may rescind or revoke any adhesion contract they've entered into unknowingly and unwillingly to clear their name of all legal disabilities and become sui juris, free man or woman. A U.S. citizen may also argue that the signature on the contract never existed because there was not full disclosure. Rescind, to abrogate, annul, avoid, or cancel a contract, nullify a contract by the act of a party. Revoke, to recall authority or power previously conferred, to annul an act by calling or taking it back. Once you can determine your citizenship, the government may presume to know who you are, but they cannot tell you who you are. To be a sovereign state citizen, you must eliminate all presumptions that you've entered into contracts that bind your performance to them. State courts were federalized in 1982 under equity, amity, maritime jurisdiction, thus have no general jurisdiction unless there are unrebutted international adhesion contracts still in force over a sovereign state citizen. Sovereign state citizens must be tried in a federal court under the diversity of citizenship jurisdiction. You have the right to see any and all contracts. You have the right to get information the government may have about you through the Freedom of Information and Privacy Act request. You have the right of discovery in a court proceeding. All contracts must be entered into knowingly, willingly, and voluntarily to be enforceable in any jurisdiction. Be careful when signing your name and enter into contracts unseen. Your name is your property, just like your fingerprint. Your name is also your power of attorney, providing you haven't given it to someone else to legally act on your behalf. Henceforth, whenever signing your name, read the fine print. Ask for the hidden contracts and always add a citation from the Uniform Commercial Code under your signature. Example, UCC 1-308. Contracts we enter into today overrule and extinguish contracts entered into a previous era. The principle of law that this is based on is called the merger doctrine. Prior oral negotiations are nullified as those negotiations merged into confluence of a written contract. See Price versus Block. Part 3, Jurisdiction. The fact that under the Organic Act of 1871, the U.S. has been organized and operating as a municipal corporation and partnering with private corporations and trading companies, it loses its sovereign immunity and descends to the level of a mere corporation. This applies to all state franchises that have incorporated as federal enclaves and issued general obligation bonds and trading in trade receivables and payables through the Court Registry Investment System, or CRIS. The Clearfield Doctrine is stare decisis upon all courts and imposes that an entity cannot compel performance upon its corporate rules unless it, like any other corporation, is the holder in due course of some contract or commercial agreement between it and the one in whom it demands for the performance are made, and is willing to produce said document and to place the same into evidence before trying to enforce its demands. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper, i.e. Federal Reserve notes and securities, are concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separated from government. See Clearfield Trust Company versus United States, 1942. Due to the securitization of all debts, the Department of Treasury, DOT, becomes a secondary obligor on all notes, bills, and bonds attached to the original promissory note. The information is then communicated to the Bureau of Public Debt that keeps a daily account of the national debt. So-called lenders can go to the DOT to demand payment for uncollected debts to repay their creditors. The DOT uses your signature on the promissory notes as an asset to issue debt instruments to prepay their expenses. Once one is able to uncover the fraud and deception that is occurring, one can use one or more of the 10 real defenses to discharge the obligation. The juristic person, or the straw man, was registered upon the application for one's birth certificate and has been declared insolvent and is being administered under involuntary receivership. The only way to free yourself as surety for these debts and obligations is through redemption SPC process and enact a bankruptcy proceeding for the strongman in U.S. bankruptcy court to get complete discharge of any and all debts. All states have adopted provisions of UCC Article 3, Section 305A of the Uniform Commercial Code, whose provisions deal with insolvency proceedings. An authenticated discharge from a federal bankruptcy judge must be honored by all states by operation of law. Congress have abrogated the state's sovereign immunity in bankruptcy proceedings. See Hood versus Tennessee Student Assistance Corporation. States, whether or not they choose to participate in the proceeding, are bound by a bankruptcy court's discharge order no less than other creditors. See New York versus Irving Trust Company, 288 U.S. 329. In adopting the bankruptcy clause, Congress was able to enforce discharge orders. There was also a provision granting federal courts the authority to release debtors from state prisons. States agreed in the plan of the convention not to assert any sovereign immunity defense they might have had in proceedings brought pursuant to the laws on the subject of bankruptcies. Blatchford, 501 U.S. at 779. Color of law. The Constitution and the Bill of Rights are still the supreme law of the land. Although many people pay lip service to the state and federal constitutions, many more Americans have never read it, and the government officials have pledged superficial allegiance while routinely violating its principles and intent. 42 U.S.C. Civil action for deprivation of rights. Every person who, under the color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in any action at law, suit, inequity, or other proper proceeding for redress. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. All acts of the state legislature and the U.S. Congress must be consistent with and derived from the Constitution for the United States of America. A colorable law or statute appears to be law, acts like a law, but ultimately does not have the authority of law. Many statutes, administrative laws, and rules and regulations present the appearance of a legal right, but are without lawful substance. It is through colorable statutes and administrative law that corrupt shadow governments are created. Colorable law is that which is in appearance only and not reality what it purports to be, hence counterfeit, feigned, having the appearance of truth. Colorable law. Commercial law and political law are synonymous terms. These laws are nothing more than bylaws of the corporation that regulates the business or commerce of the government agency, international or domestic corporation. They are listed variously as political code, commercial code, statutes, public policy, and as such are all under color of law. The Federal United States is a foreign corporation. The U.S. Congress writes bylaws their members, i.e. U.S. citizens, must obey. The real substantive laws of a state, which are judicially enforceable, although they may appear under the listing of statutes as civil code, penal code, or variations thereof, may generally be thought of as contained within the organic law as codified common law. Acts performed under color of law by any federal, state, or municipal government or its employees may include illegal acts done by government officials, bureaucrats, employees, etc., not only within, but also without and beyond the limits of their lawful authority. These acts are illegal, so when an official steps outside the bounds of the lawful authority, they become personally liable for the offense, as would any private citizen. The appearance or semblance without the substance of legal right, misuse of power possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state, is action taken under the color of state law. 42 U.S.C. Any government official, employee, or agent of the corporate government, police officer, county sheriff, judge, magistrate, attorney, congressman, senator, bureaucrat, IRS agent, federal agent, employer, including the President of the United States, who conspires to deprive a sovereign state citizen of any right or privilege secured by the respective state constitutions, federal constitution, and Bill of Rights, or acts improperly under the color of law is subject to criminal prosecution in both the individual and official capacity. The sovereign state citizen has powerful, lawful tools to protect one's unalienable rights and make all government accountable to the Constitution and the law of the land. A thorough understanding of the law and how the legal system actually works is required to defend one's rights against the intrusions of government. Public officials are not immune from suit when they transcend their lawful authority by invading constitutional rights. See AFL-CIO versus Woodward. 18 U.S.C. Conspiracy against rights of citizens. If two or more persons conspire to injure, oppress, threaten, or intimidate any citizen in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined not more than $10,000 or imprisoned not more than 10 years or both. And if death results, they shall be subject to imprisonment for any term of years or for life. 18 U.S.C. Deprivation of rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the constitutions or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined not more than $1,000 or imprisoned not more than 1 year or both. And if death results, shall be subject to imprisonment for any term of years or for life. There is no risk of criminal prosecution when one in good faith challenges an agency. Casey versus FTSCA. Uniform Commercial Code is colorable law, and is not law, but gives the appearance of law and is upheld by the courts as law. This colorable law is known only to judges and licensed attorneys, although it was designed to protect the common people from unscrupulous merchants and bankers. Recent statutes have been passed which allow the government to seize and sell immediately the real and personal property and private papers of accused drug dealers before the cases even go to trial. Even more shocking is that now these laws are now being used in other cases where the government feels the need to inflict immediate and disabling hardship on the defendant in order to keep him or her from presenting a viable defense. Fortunately, these statutes have been declared unconstitutional by the Supreme Court. There is no liberty if the power of judging be not separated from the legislative and executive powers. No legislative act contrary to the Constitution could be valid. Alexander Hamilton. There are no longer any genuine Article III courts except those being formed by dedicated patriots throughout the U.S. The judges no longer have the powers and immunities of Article III judges, but have only ministerial powers in legislative tribunals as per Article I, or the territorial courts of Article IV. Article III courts were created by the Constitution and are legitimate courts of the land based on substance and law. The laws passed and the courts created under the exclusive legislative authority of Article I are not required to be consistent with the Bill of Rights or the common law. America is no longer a nation of laws, but of petty tyrants operating as bureaucratic tribunals, ergo construction contractors board, building and planning departments, licensing agencies, etc. A statutory jurisdiction has been in effect and created without constitutional authority. Justice and common law are not available unless you know how to invoke them. There's a bit of magic, a lot of study and preparation, and a waving of the magic wand of words and citations. As colorable law, the UCC is based on negotiable instruments, a medium of exchange not based on real substance, paper money, checks, credit, Federal Reserve notes, or other securities. The common law is based on substance, gold and silver, while Uniform Commercial Code is based on bankruptcy, FRNs. The Negotiable Instruments Act of 1938 has in effect bound all corporate entities of government together along with their franchises, i.e., U.S. citizens, in a vast system of commercial agreements. Everyone in this system is a statutory law merchant dealing in negotiable paper under limited liability for the payment of debts. This is what has dramatically altered our court system from one under the common law to a legislative, administrative, tribunal system of commercial colorable law based on negotiable paper. This is how the U.S. citizens are held to the letter of every statute of federal, state, county, and municipal government unless they exercise the remedy provided within the UCC and through our redemption SPC process. All contracts since the New Deal and the federal bankruptcy of 1933 have been colorable contracts. Ever since America went off the gold standard in 1935 and declared FRNs as fiat currency or legal tender, we've been using the colorable consideration of FRNs instead of gold to negotiate these colorable contracts. The term colorable was changed to commercial, and an unconstitutional statutory jurisdiction was created in the courts to enforce these colorable contracts. This statutory jurisdiction is legislative rather than judicial in nature. Thus, the equity admiralty courts were merged with the common law courts to enforce these commercial agreements. This is obviously unconstitutional as it dissolved the independent judiciary and created a jurisdiction not authorized by the Constitution. Without a legitimate payment of debts and contracts based on gold or silver, a system of colorable law was introduced that brings every American into a commercial contract with the corporate government monopoly, state socialism. Although our unalienable rights cannot be taken away from us, we may contract them away at will. All this has been accomplished by carefully orchestrated plans and practices of the Federal Reserve Bank and through the quiet introduction and implementation of the Uniform Commercial Code in all 48 corporate states in U.S. possession. Texas was the last state to adopt the UCC in 1967. The entire taxing and monetary systems are hereby placed under the UCC, the Federal Tax Lien Act of 1966. Under the UCC, we the people are obligated, as in any commercial agreement, to the terms and conditions of the contract, but we are unaware of the terms of this contract, which are scattered and hidden in millions of pages of regulations, statutes, codes, and ordinances at the federal, state, and local levels. Most of us are even unaware that such an agreement exists. The prevailing benefit being given to the American people is the privilege of discharging debt with limited liability instead of actually paying debt with lawful money. You cannot be sued for not paying your debts. If you exercise the benefits of a contract, it is presumed that you intend to meet the obligations associated with those benefits. If you can get everybody to exercise the benefit, then you've got people obligated, thus under federal jurisdiction. Every system of civilized law must have remedy and or recourse. Remedy, a way to get out from under that law. Remedy means rights with or without tribunal, UCC 1-201. Remedies are to be liberally administered, UCC 1106. Recourse, if you have been damaged by the law, you can recover your loss. The Social Security number is the foundation instrument contract upon which the courts presume to have standing to send you a presentment, i.e. citation, ticket, fine, penalty, or invoice. When you are forced to use a benefit or privilege of the government, ergo postal service, highways, public utilities, welfare, city services, limited liability, FRNs, etc., you must first reserve your rights under the common law, not to be bound by any contract or commercial agreement that you do not enter into knowingly, voluntarily, and intentionally. See UCC 1-207. For U.S. citizens, this is a remedy against the tyranny inherent in the American courtroom today. Once the court has acknowledged your reservation of rights in the common law, you must design a strategy for your own affirmative defense. Affirmative defense, one that serves as a basis for proving some new fact, whereby a defendant offers new evidence to avoid judgments against him or her, derived from the common law demur. There is a remedy and recourse to be found in this colorable law. There are specific sections in the thousands of pages of the UCC that can be used to assert our common law rights. More in-depth study is required to develop a personal strategy toward using these remedies in an actual court situation. Also, find references to these remedies and recourses in the state law as well. Liberty lies in the hearts of men and women when it dies there. No constitution, no law, no court can save it. Where do you stand, citizen? Judge Learned Hand, 1961. UCC-1207. The making of a valid reservation of rights preserves whatever rights the person then possesses and prevents the loss of such right by application of concepts, waiver, or estoppel. A reservation of rights can only reserve a right that is existing. The failure to make a reservation thereof causes the loss of the right and bars its assertion at a later date. Waiver, an intentional and voluntary surrender of some right. Estoppel, a restraint, arises where a person has done some act that the policy of law will not permit him to deny or will not permit a certain argument because it would lead to an unjust result. Without prejudice implies that no special privileges, benefits, or title of nobilities exist. Any expression indicating an intention to preserve rights is sufficient, such as without prejudice, under reservation, or with reservation of all our rights. Anderson on the UCC. The code is complementary to the common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law, unless there is a clear legislative intent to abrogate the common law. Some affirmative defenses. UCC 1-103. Prove duress or fraud if you were told that you had to perform such and such an act, or that you were influenced to believe it was illegal not to perform such and such an act, or that you were coerced or misled into believing that you had to enter such and such a contract. Prove the government's fraudulent behavior and false presumptions that any contract with the government must be under threat, duress, or coercion. Prove that the government is acting in a fraudulent manner by claiming to be bankrupt. UCC 2-302. Prove an unconscionable contract or clause is void, especially for consumers. Unconscionability has generally been recognized to include an absence of meaningful choice on the part of one of the parties together with contract terms which are unreasonably favorable to the other party. Judge Wright. UCC 3-305. Government officials have a duty to inform you of your rights or remedies. Government officials have a responsibility to tell you of any pending responsibility on your part and to inform you of all the terms of the agreement pursuant to UCC 3-305. Produce all documents held in due course that provide any legal disability. So if you refuse to participate in the bankruptcy actions of the federal United States government, liability discharges, presentment denied or refused, pursuant to UCC 3-305. Presentment, a written accusation of the crime by a grand jury under the common law, an international admiralty maritime contract, notice of deficiency, traffic ticket, bill or adhesion contract. UCC 3-401. No one is liable on an instrument unless and until he or she has signed it. UCC 3-403. You have a right to be told who the principal is. UCC 3-505. Insist on a presentment, notice of deficiency or contract without dishonor and refuse for good cause. Demand to see the original international contract or presentment with the federal government, evidence that I am on a federal U.S. citizen, a federal employee operating a vehicle for commercial purposes, etc. Do not admit to the contract. Demand they produce the signed authorization. Presentments must be duly made based on proper foundation, recorded, perfected, negotiable instrument. UCC 3-505. Counter demands by a party to whom presentment is made. The party to whom presentment is made may, without dishonor, require exhibition of the instrument that created the liability, reasonable identification of the person making presentment and evidence of his authority to make it if made for another, and that the instrument be produced for acceptance or payment at a place specified in it, or if there be none, at any place reasonable in the circumstances, and if signed, receipt of the instrument for any partial or full payment and its surrender on full payment. 2. Failure to comply with any such requirements invalidates the presentment, voids it, but the person presenting has reasonable time in which to comply, and the time for acceptance or payment runs from the time of compliance. UCC 3-505. The presenter or his authorized agent may treat the presentment as dishonored if the person to whom presentment is made makes counter demands which are not authorized by UCC 3-505, or places unreasonable conditions on demands authorized by that section. If counter demands are proper, the presenter must comply with them, and the code gives a reasonable time in which to respond. Correspondingly, until there is such compliance, there is not further duty upon the other person to whom presentment is made, and the time for acceptance or payment runs from the time of compliance. UCC 3-601. Discharge any presumed liability if you've been given or find no remedy or recourse. UCC 3-608. Revoking your agreement in colorable law. UCC 2-609. Demand assurance and due performance as it relates to promises made. Right? Demand assurance before entering into a contract that the purchasing power of FRNs will be as good at the end of the contract as the ones you pay in the beginning. Obviously, they cannot guarantee that. Did they refuse or did you? A no interest contract is void and unenforceable. So those are a few of the affirmative defenses that you can use to void a colorable contract. That is the end of our presentation today. Hope you guys enjoyed it, and I hope you learned a lot. We'll be seeing you for the next webinar. Thank you.